So in this presentation, we want to talk about invalid marriages under the Marriage Act of Nigeria. Invalid marriages under the Marriage Act of Nigeria. I'm sure the Marriage Act of Nigeria is the act under which you celebrate a statutory marriage, or what we call an act marriage. This kind of marriage is a monogamous marriage. It has its principles well laid out by virtue of the provisions of the Marriage Act. The statutory marriage that we are talking about is regulated by this Marriage Act and the Matrimonial Causes Act when you have matrimonial causes. Therefore, we want to look at one aspect of that Marriage Act. The Marriage Act itself is principally concerned about celebration of statutory marriages, and that act has been in existence since 1914 as an imported legislation. It imports a marriage that is not customary, that is European, that is British, into Nigerian law. The marriage that it introduces that we are talking about does not tolerate any other kind of marriage. It is monogamous. In other words, a man that marries under the act or a woman that marries under the act does not have the capacity to celebrate another marriage with another person while that statutory marriage is subsisting. Now, if you look at that act, under Section 33, it talks about invalid marriages. And we're going to look at some of these provisions together. 33.1, and I will read that section to you. It says, and I read, no marriage in Nigeria shall be valid where either of the parties thereto, at the time of the celebration of such marriage, is married under customary law to any person, other than the person with whom such marriage is had. So this section of the Act, especially when you consider when that Act came into Nigeria, was meant to address a particular mischief. A mischief in which somebody is already married to Mrs. A under customary law, and now purports to want to marry under the Marriage Act to another person. As long as the initial customary marriage is subsisting, there is no capacity to marry under the Act. The customary marriage that it refers to is a polygamous marriage. So the question of validity of any of the marriages is a reflection of precedence. The first in time prevails. You cannot say because it's an act marriage, therefore it should have superiority over a customary marriage. No, it is a question of when was which is the first marriage and what is the status of that first marriage. If the spouse is late or they are divorced, then you have capacity. But if that is not the case, then that marriage must be recognized as that initial marriage as the valid and subsisting marriage. Now, so if somebody purports to do that, and this kind of situations usually arise actually when someone dies and they are trying to determine those who are the successors to the estate, especially when the person has died intestate, has not left a will, and then suddenly someone surfaces and says I'm the wife. Another person says I'm the wife, and this is the wife we have always known. So usually this is a situation in which you would find people having to prove the validity of their marriages. Now, if you look at section 33.2, and I'll read that section out again to us. It says, a marriage shall be null and void if both parties knowingly and willfully acquiesce in its celebration. A, in any place other than the office of a registrar of marriages or in licensed place of worship, except where authorized by the license issued under Section 13 of this Act. Now, before I go on, let's look at that general provision of Section. It says a marriage shall be null and void. So it's talking about marriages that are null and void. And this section says if both parties knowingly and willfully acquiesce in a celebration. So this section imports connivance, collusion. It imports the fact that both parties to a marriage are aware that they are flouting the law. If one of them is not aware that the law has not been followed, the marriage will not be annulled. Because the nature of marriage is such that the law is interested in sanctity of marriage. Law is not really interested in breaking homes, in just dissolving unions, because it is not a commercial transaction. The interests that are there, as they are emotive. You have children, you have so many issues that are tied to marriage, and so unless it is evidently clear that there is a need to annul the marriage, the court will not be willing to do that. So the statute says both parties must knowingly and willfully, and the courts in Nigeria have followed the English position to say that that actually means that it must be intentional, and it must be that both parties are aware that they are disobeying the law. And I will just give you examples of some cases in this regard as we go on and read the sections. Now, it says A, in any other place, if you are accused. So it says, if you celebrate your marriage outside the stipulated statutory places, the marriage will be null and void. What are these places? If you look at the provisions of the Marriage Act regarding celebration of marriage, you can only get marriage under the act if you are disposed to do so in the office of the registrar of marriages, or in a licensed place of public worship, a church that has been licensed by law to celebrate marriages, or if you have been given a special license by the registrar under section 13 of the Marriage Act to celebrate the marriage in any other location, okay, the location specified in the special license, you can also get married there. Then statutory marriage may also be celebrated in the office of the Nigerian Diplomatic Mission abroad. These are the places that statutory marriages may be celebrated. So if you both decide to go and get married on the beach, for instance, without the special license of the registrar, purporting to be married under the statutes, that marriage is null and void. But don't forget what we said, that both parties must knowingly and willfully acquiesce in the celebration. Or if you marry under a false name or names. For this, why is this significant? Like I said, marriage impacts life significantly, more than any other transaction known to law. And so it is not to be celebrated in secret. It is a declaration per verbal presente in the public space, in the presence of witnesses. When you look at the provisions of the Marriage Act, from section 7 down, about celebration of statutory marriages, you will see that it must be done publicly. There must be at least 2 witnesses. You must know that you are getting married. In fact, there must be publication of notice of marriage at the office of the registrar. That people must be aware and they can raise objections. And so you cannot be aware where people have changed their names. You cannot be aware where the parties have changed their names. And so how do we know if we can object to a marriage? So if both of them knowingly and willfully acquiesce to celebrate the marriage under false name or names, maybe one of them or both of them, of the parties, the marriage will be null and void. Or without a registrar certificate of notice or license issued under section 13 of the Act. If you look at these provisions of the Marriage Act, like I said earlier, for you to get married, you must first obtain a certificate of notice of marriage from the office of the registrar. It is that my registrar's certificate that you take to the licensed place of worship, public worship, for instance, or you use at the registrar's office to get married after the period of waiting has elapsed. Okay, you do not get married just in one day. You need to give notice. There must be room for people to know that you are getting married. Then after that stipulated notice, the registrar's certificate is issued, which is like a license to proceed to get married. If you marry without obtaining this very significant document, the marriage is null and void. If you don't have that registrar certificate, the other option is that you are given a special license which dispenses with the registrar certificate and which stipulates where you should get married and dispenses even the giving of notice dispenses with the giving of notice of marriage. So what are we saying? The conditions for celebration of marriage, it must be followed under the law. If they are not followed, and both parties know that these conditions have not been met, the marriage would be annulled. Don't forget, I keep emphasizing that principle provision. Then it says that if it is celebrated by a person not being a recognized minister of some religious denomination or body or a registrar of marriages, apart from celebrating it in the place that has been stipulated by law, it must be conducted, the marriage must be conducted by the registrar of marriages. If you are doing the marriage at the registrar's office or any other place that the special license stipulates that you should get married, then the registrar of marriages must conduct the marriage. Or if you do not do it there, then the minister of religion of a religious denomination which has been licensed to conduct marriage. So if, for instance, you are getting married in the Baptist church located at XYZ Street, and that church is licensed to celebrate marriages, when it comes to joining the couple, in the wedding, during the wedding ceremony, so many activities will be there. There'll be message, there may be the Holy Communion service, there may be this or that. But we are not concerned about that. The person, at the point when they want to join the marriage, they want to join the couple, the person that is the minister of that church is the one that will join the couple. Let him be the youngest person on the altar that day. You can have the bishop, the general overseer, maybe the parents of the bride come from one church, the parents of the groom come from another church, the bride attends another church, the groom attends another church. All of them are on the altar to come and celebrate with the couple and conduct the wedding. They can do any aspect of the ceremony, but the joining of the couple, let it be just a young minister that is the pastor of that licensed place of worship will be the one that would join them together. Otherwise, the marriage may be annulled. Okay. Now, then if you look at so these are the provisions in section 33(2) of the Marriage Act. Section 33(2) of the Marriage Act. Now let's look at how the laws have been interpreted, and I mentioned some cases to you. I told you earlier that the Marriage Act is an imported legislation, is taken from English law, and English court have always pronounced on the fact that marriage is a sacred institution that should be protected. It is fundamental unit of society, it is a fundamental medium of creating the basic units of society, the family. So they try to protect it as much as possible. And the English cases that have interpreted a similar provision in English law, what the courts have done is to say that once there is no connivance or knowledge of both parties, they will sustain the marriage. In the case of cheap chase, for instance, the wife gave a wrong name to the knowledge of both parties because she gave her maiden name even though she was a divorcee. And then when the question of the nullity of the marriage arose, the court said that the name was given to conceal her identity and the marriage will not stand. Then you have dancer and dancer. In dancer and dancer, the wife was born, her birth name was Knight. Okay, her birth name was Knight. But at age 3, she was given the name of her stepfather, and she had to use that name throughout her growing up years. She was known as Roberts. So when it was time to publish the banns, she was advised to use Roberts because that's the name by which she was known. She didn't use her father's name, which was Knight. And the question of the validity of that marriage, and the court looked at that provision about knowingly and willfully acquiesce. The intention, the mischief is that you don't want people to commit fraud against each other and against this larger society. Assuming one of them is married and the wife does not see the real name, she will not even know she ought to object to the marriage. So the court, in the case of dancer and dancer, said that the marriage will not be annulled because even the essence of using the name robot was actually to show her real identity. Nobody knew her as Knight. So if she had used Knight, it would even have been a bit, it would have been deceptive. So the court did not annul that marriage. Then you have Truth and Barrow, where the wife adopted another name so that people will not know that she was the one getting married, and the court annulled the marriage. You have Nigerian cases too, Obuekwe and Obuekwe and Anoike, Akuidike and Akuidike, which with similar decision. In these cases, the court emphasized the fact that both parties must be complicit in doing the wrong thing. And there was evidence in these two cases that the parties concerned, one of them was ignorant. In one case, the wife was supposed to thought the husband was the one running around to prepare the wedding ceremony, and then she assumed that he had complied with the provisions of the law and told her that they were already married. Meanwhile, it did not. There was no wedding took place, but she thought they were married because she left, the husband to prepare the marriage. And you have had cases where the man would even leave the wife outside the registry, go in, come out, and tell the woman we are now married. Of course, they might seem ridiculous to you today, but it just showed the level of development when those cases were in place. And the courts have held that in such cases, both parties were not complicit. The other one was innocent. So to that extent, that marriage remains valid. Now, if you look at Section 33 now says that no marriage shall, after celebration, be deemed invalid by reason that any provision of this act other than the foregoing has not been complied with. So Section 33.3 is saying that the conditions in 33.1 and 2 are the only conditions that would render a marriage void under the Marriage Act. Okay, and so if and of course the conclusion then is that other provisions of the law where they are not complied with are not significant to the extent that they are not listed in this provision. Now I want us to look at Section 24. Section 34 of the Marriage Act. It says all marriages celebrated under this act shall be good and valid in law to all intents and purposes. So the section would rather presumes that once you celebrate this marriage under the Marriage Act, it is good and it is valid, unless the contrary is shown in the light of Section 33 of the Act. Then you look at Section 35, and it says any person who is married under the Act or whose marriage is declared by this Act to be valid shall be incapable during the continuance of such marriage of contracting a valid marriage under customary law. So if you get married under the Marriage Act, you lack capacity to marry under customary law. And if you look at the Matrimonial Causes Act in Section 3, it's also one of the reasons one of the grounds where a marriage will be void. Because like I said at the beginning, the capacity to marry under the Act is lost once there is a prior subsisting marriage or prior statutory marriage. So here, any person who is married under this act or whose marriage is declared by this act to be valid shall be incapable during the continuance of such marriage of contracting a valid marriage under customary law. But they say, as I first said, nothing in this act contains shall affect the validity of any marriage contracted under or in accordance with customary law. So the act is saying, we are not saying customary marriage is not valid, but we are saying that once you marry under the Marriage Act, you cannot contract a customary marriage. If you give this provision a literal interpretation, what it actually means is that those of some of us who will go and marry in the marriage registry on a Wednesday and then go to on Friday to sit down in the house or in an event center and contract a customary marriage, what we call engagement or wine carrying in Nigeria. What we are doing, if we look at this provision literally, is wrong. Because you're already married under the Marriage Act. Because it does not say to somebody else. It says whoever is married under the Act is incapable of getting married under customary law. Of course, what that means is that those ceremonies are just social events that we conduct to entertain ourselves. So in terms of reform, one would say that what this section needs is that it should be stipulated that the subsequent marriage should be with a third party. Okay? Then I want us to look at some other provisions of the Marriage Act with regards to capacity. And these are about offenses. If you look at section 44, it talks about personation in marriage. Whoever personates another person in marriage or marries under a false or description under a false name or description with intent to deceive the other party to the marriage shall be liable to imprisonment for 5 years. So if you marry under a false name, or you pretend or you try to deceive the other person with regards to identity, it says it's a crime, imprisonment for 5 years. Because I had people that will just wake up one day after 5 children. They thought they are married, don't know that this person already has a statutory marriage or a customary marriage to somebody else in another town or village. Unfortunately, these discoveries are made sometimes when the man is dead. And so you cannot have nobody to prosecute. Fictitious marriage, section 45. Whoever goes through the ceremony of marriage or any other ceremony which he or she represents to be a ceremony of marriage, note that marriage is void on any ground and that the other person believes it to be valid shall be liable to imprisonment for 5 years. So these criminalizations address section 35, that where the other party is not complicit and you have deceived that person into believing that you are married, you know that one of the grounds has not been met. You know the fundamental principles of this marriage act have not been met, that it's an offense liable to imprisonment for 5 years. Then 746 says contracting marriage under this act when already married by native law. We talked about 73(1), which says that you lack capacity once you are married under the customary law to contract and act marriage. So 746 makes it a crime, also punishable by 5 years imprisonment. Then when you contract marriage by customary law, when already married by the act, you are already married under Marriage Act. You now go ahead and marry under customary law another person. That is the intendment that we can believe this section is meant to cover. It says it's 5 years imprisonment. It does not say to another person, but you know that if you apply it in the literal sense, that means a lot of people are committing crimes, because many people would marry under English law. They will go ahead and marry under customary law. They go to registry. We do what they call triple marriages or dual marriages, marrying the same person under different systems of law. It has become the norm in Nigeria. But if you look at this section 47, it says that if you are married under customary law, when you're already married under the act, so if you first do the registry marriage at the registry, and you go ahead and marry the same person under customary law, in strict letter law, literal interpretation of these sections, it means that you are committing an offense. But definitely, if it is to another person, it is an offense. The prosecutorial aspect of these offenses is another thing entirely in Nigeria. Then 748 talks about whoever, knowing that the written consent required by this act has not been obtained, shall marry or assist or procure any other person to marry a minor under the age of 21 years, not being a widow or widower, shall be liable to imprisonment for 2 years. The Marriage Act requires that where people are under 21, you obtain the parents' consent. The act was made, of course, like I said, 1970, 1914. But you don't forget that under the Child Rights Act, you cannot marry somebody under 18 years. It is impossible. Nobody under 18 years has capacity to marry. So you cannot say you have obtained parental consent under the Marriage Act and marry somebody under 18 years. Unfortunately, the Marriage Act, when it was made, talked about 21 years and to get parental consent. It did not stipulate age of marriage, but it says, so what you will see is that if you use the Child Rights Act, which stipulates 18 years, for instance, then you say that the person that is on 18 years or under 21 years, you should obtain parental consent. And where you do not obtain it, this section makes it an offense punishable with imprisonment for 2 years. So that means there is need to align these provisions of the law. What would have been therefore evident in this discussion today is the fact that so many things that we do in this Nigerian society contradict the law. We conduct marriages because we want the affirmation of the customary system. We also want the affirmation of the English system. So sometimes these things that we do may just constitute mere social events, especially when we are there with the same person. You marry one person, you marry your wife under the Marriage Act by going to the registry, then you go to the church with the registrar's certificate, and they conduct a statutory marriage for you again. Then you do customary marriage. Sometimes the customary marriage is done before these act marriages, sometimes it's done after. Whichever may be the case, if it is with the same person, usually there are no legal problems. And it has been held that the statutory marriage done after its customary marriage converts the statutory marriage and converts the customary marriage or overrides the customary marriage, and all that you have is actually a statutory marriage. And that it's usually where you have a person, typically a man, marrying more than one wife, when there is an act marriage in existence before the customary marriage, subsequent customary marriage, or supposedly act marriage, which ordinarily should not be possible under the law. But sometimes you have people that will go abroad, in this era of Japan, they go abroad, they are already married in Nigeria under the Nigerian Marriage Act, and then go ahead and purport to get married to somebody else in other jurisdictions. So there are provisions of the law that address this. What we are able to do today is to discuss how the Marriage Act impacts the validity of statutory marriage. And we can take it home from this discussion that where you lack capacity or where you have not complied with the provisions of the Marriage Act regarding celebration of marriages as specified expressly under the Marriage Act, that marriage will be null and void. I'll see you at the next presentation.